Good morning, everybody. It's time to get started. Are you ready? Let's roll, nerds. Well, ladies and gentlemen, it's Saturday, and today is a big show. We're going to start out in Bay County, Florida with Judge Van's cattle call. Ladies and gentlemen, this morning we are going to look for the highest bond. Then we're going to head to Wayne County, Michigan, where the Judge DeSantos and Judge Washington are facing off with some really frustrating individuals. Judge DeSantos has a rude lawyer in front of it, and Judge Washington has a pretty rude defendant to deal with. And we're headed back down south to Fulton County, Georgia. And ladies and gentlemen, Judge McBurney has a murdering dog thief who wants to make a record, and what a record it is. After that, we're going to finish the day off back in Washtenaw County, Michigan, with our favorite Judge Simpson. And he's got a very troubled case that we've been following, and it all starts right now.
So we were talking about
Bulls on parade, back in black. I mean, I've got some walk up. See, I'm all about walk up music.
We're gonna no longer all rise.
Theme music.
We're gonna do walk-in song. Yes. And then there's gonna be bands busting to the door.
Crazy Train. The old Chipper Jones walk up.
Yes.
I'm telling you, I'm here for it.
At least on Fridays, we need some.
Fridays, we could do that on Fridays. We could start doing that on Fridays.
The week we've had, this month is good.
Absolutely.
Probably put everybody in a better mood.
It would.
Everybody's always in a good mood this evening.
That's true. I mean, we're usually it's pretty laid back, especially on Fridays. Jordani,
Hello, Your Honor.
how are you doing, sir?
I'm doing great, Your Honor. How are you?
Oh, better than I deserve. I promise. Raise your right hand for me, sir. Do you swear or affirm you'll truthfully and accurately interpret the conversation of court in the defense today?
I do.
Now we're just waiting on Ms. Fanbro. Look at us. Okay. All right. Okay.
Yeah, it's here.
Ms. Fanbro, what's taking so long? Why?
Grown folks talking over here.
Wow.
You see these grown folks talking over here?
10:33. Look, I've never let that stop me from interrupting. Already one of those days? Hey, it's Friday.
Red X, state your name.
Ms. Hammond, you're fully court on a failure to pay fines for was originally in possession of less than 20 grams of marijuana and paraphernalia. You've been sentenced to serve 10 days in the Bay County Jail, but you may purge out upon payment of $420. That's weird. That's a weird number for pot and a paraphernalia charge.
Did you say that, Joe?
420.
All right.
420 or
Step to
10
your right
days.
to the T.
What
Yes,
kind
ma'am,
of
from
judge
the
is someone to pay $420 on a?
You did. Next.
Yes.
Red X, ma'am,
It really is.
state your name.
Courtney Allender.
Ms. Allender, you're fully court on a failure to report child abuse and neglect of child. Do you understand those charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Mr. Graham, you represent Ms. Allender?
I do, Judge. Let me make you aware of a few
Is
things.
this the school case?
To my
This is the
knowledge,
code-
Judge, she
this
has
is
no
the codependent
prior
of the
record,
PE teacher. Yeah,
sir.
I'm just making sure that this is the companion case to the PE teacher.
That is correct, Judge. And Miss Allender has lived in Bay County for most of her life. To my knowledge, she has no prior criminal record. And most importantly for your decision is immediately upon learning of the warrant, she contacted me. They retained my services, and we made arrangements last night for her to surrender. And she went into the Bay County Warrants Division at about 8:30 p.m. and voluntarily surrendered to their authority, Judge. She is not a flight risk.
Right, and she's a para at school. Is that correct?
Yes, sir, Your Honor.
Okay, I got it. I'm up to speed now because I think I saw the warrants. You know, sometimes it's better to be a witness than a defendant. I'm just thinking out loud, Mr. Graham.
I agree.
All right, so pretrial release, no contact with the alleged victim or co-defendant. Court date's going to be May 19th at 9 o'clock, but she needs to be at the pretrial release office before 9 o'clock Monday morning.
Yes, sir, boss. Thank you.
All right, step to your right to the T.
Have a good weekend.
When the
Will.
green light comes on, sign. Next. Red X, ma'am, state your name.
Mr. Runyon, you fully court on an out-of-county warrant. It's a Jackson County warrant for violation of probation or resisting charge. You understand that, ma'am?
Yes, sir.
Judge Garcia, in her infinite wisdom, has already held without bond. Your court date's going to be, your return date's going to be March 21st, but you should be long gone by then.
Step to your right to the T. When the green light comes on, sign. Next.
Oh, females today.
Come on in.
Also a doc.
He's targeting.
State your name, sir.
William Dalton Charter.
Mr. Charter, you're before the court are disorderly intoxication, resisting officer without violence, and theft. You understand the charges?
Yes, sir.
I should be giving copies of paperwork and advised of your rights. Is that true, sir?
What is it, sir?
Been advised of your rights today?
Yes, sir.
You got a copy of your paperwork?
Yes, sir.
Based on your application, you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Death, criminal history, Mr. Charter?
Got him on felony probation.
Case number, ma'am?
24-34-56. Yeah.
All right, Mr. Charter, on the it's 7th, right?
Yes.
I'm a day off all week. At least I'm writing 25 now instead of 24. That was a chore. On the disorderly intoxication bonds, 500. The resisting without is 500. 1,500, and the petty theft is 1,000. Court date's going to be March 10th at 1 o'clock, and I'm signing a warrant for violation of probation in case 24-34-56. Good luck, sir.
Right, step to your right to the T. When the green light comes on, sign. Next. Step on the red X, sir. State your name.
Bobby Holmes.
Mr. Holmes, before the court on a failure to appear for a retail theft charge. You understand that?
Yes, sir.
Based on your application, you do qualify. I'm going to go ahead and appoint the public defender to represent you. Your bond's been preset at $1,500. Your court date is March 10th at 1 o'clock. Good luck, sir.
Step to your right to the T. When the green light comes on, sign. State your name, sir.
Travis Smith.
There you go.
Mr. Smith, before the court charged with violation of pretrial conditional release on domestic violence. You understand that?
Yes, sir.
They really are recording those phone calls. I don't know how many times they have to warn you about that, but they really are. I swear they are.
Yes, sir.
Based on your application, upon which you do qualify, I'm going to go ahead and appoint the public defender to represent you, so you have an attorney.
Okay.
Judge Smith told you not to do it. What? We gotta listen to Judge Smith. She's scary. All right, bond set at 5,000 on the violation of pretrial release. And I'm revoking release in 24-32-26. No contact with the alleged victim. Court date's gonna be March 10th at 1 o'clock. Good luck, sir.
All right, I got a question, sir.
Shoot.
I have, this is my second violation of no contact order. My first one, I have court due, March 13th. And I got court March 10th for my felony, but they dropped my felony to a misdemeanor. So I don't know. They sentenced me to lifeline. So I'm trying to see if we could put all of it together as one court date since they're all going to be misdemeanors.
You can resolve them all. Dave.
Okay. All right. Thank you.
Yep.
Sign where the light is. Next.
It's hard of listening.
You're that next. Oh, go ahead, state your.
Mr. Godbolt, you're for the court for violation of no contact order. Do you understand that?
Yes, sir.
Judge Smith told you not to do it too. But here we are. Mr. Godbolt, when you make those phone calls, do they tell you that's being recorded?
Yes, sir.
Yeah. And that's usually enough to make somebody think, well, they might listen to this, but not you, not you. All right, Mr. Godbolt, bond set at 5,000 on the violation. Court date's going to be March 10th at 1 o'clock. No contact with the alleged victim, and I'm revoking release on 25/23.
Step to your right. Next. State your name.
Brandon Waters.
Mr. Waters, before the court for petty theft, you understand the charge?
Yes, sir.
I'm seeing a piece of paperwork and advise your rights. Is that true?
Sir?
You advise your rights today?
Yes, sir.
Got a copy in your, or in your
Yes, sir.
pocket? Yeah, got it. Deputy, criminal history on Mr. Waters?
Nothing says 21. That was habitual possession of weapon or ammo, another habitual VOPs through 21. Other than that, there was a DWLSR 14, child use 13.
Bonds 2,500, no contact with Walmart. A fate worse than death. Court date's gonna be March 10th at 1 o'clock in front of Judge Dyer. Good luck, sir.
I'll step to your right to the T. When the green light comes on, sign. Next. Red X, sir. State your name.
Michael Goddard.
Mr. Goddard, before the court on a failure to appear for a pretrial conference. Bonds set at $7,500. Your court date is March 13th at 9 o'clock.
Step to your right behind him. Next. Red X, sir. Face the TV and state your name.
Cameron, 20.
Renee, before the court charged a false report of a crime. Do you understand the charge?
Yes. Yes, sir.
I seem to be giving copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, finds you do qualify. Go ahead and appoint a public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history?
Last year was a reckless resisting and a no valid, and that's it.
Lisa on his own court date is March 10th at 9 o'clock.
Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. Here you go. State your name.
Brandon Sweeney, sir.
Mr. Sweeney, you're for the court charge. Domestic violence assault. Do you understand that charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights.
Yes, sir.
Based on your application, finally, this due to your application, you do qualify. I'm going to go ahead and appoint the public defender to represent you. So you have an attorney now. Any question about that?
Thank you, sir.
You're welcome. Deputy, criminal history?
19 less than 20, the grand theft auto, I don't know, false resisting with criminal mischief, possession of uncurrent bills with marshal holds, detainer holds, it goes through 24 and history back to 11.
Can I speak?
He can hear you.
Yes, please.
Judge, Your Honor, I just came home from the feds and I've been out a year. I'm actually, my parole officer, I'm going to a program tomorrow to go to reentry through the feds. This is my mother, me and my mother. She actually, if you stayed in there, you see where she hit me several times with a broom. I did call her the B word. I should have done that. but he
Don't
took
talk
me to
about
jail.
what happened. Don't talk about what
Oh, I'm sorry,
happened.
sir. I didn't hear you that. I'm sorry. I got a program tomorrow and this is, I didn't touch no. Sorry,
Because
sorry.
they're not gonna take you with a pending charge. Your bond's 5,000, no contact directly, indirectly, or through a third party, alleged victim. Court date's March 10th at 1 o'clock.
Monday. Step on the T. When the green light comes on, sign.
1,000 on this.
State your name.
Actually, it's about, I dropped a 0 because it was your mama. I should have put it 50,000 on a misdemeanor.
I'm sorry. You're right. I'm sorry, sir.
And I can change it.
No, sir. I apologize. I stand corrected. I'm ignorant. I'm sorry. You got that, sir.
State your name, sir.
Shanty Williams.
Mr. Williams, before the court charged accessory after the fact, robbery with a firearm, accessory after the fact, false imprisonment, accessory after the fact, grand theft of motor vehicle. You understand the charges?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, if I do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Deputy, criminal history, Mr. Williams?
Got him on an interstate probation for homicide/manslaughter. Let me see. I don't know. What state?
Alabama.
Alabama.
They let you out on probation on a manslaughter charge?
I did my time. So
Okay.
did my time, bro.
So you do, how much time?
Locally. Oh,
I got 2 years left on probation.
Well, that's, okay.
They only gave me. They only,
Here's the deal, Mr. Williams, you're not gonna leave Florida till you're an old man.
you think so?
I do.
I'm from here though, so I ain't
Okay.
y'all just
All right.
going on my credit.
The accessory after the fact, robbery with firearm, bonds 250,000. On the accessory after the fact, false imprisonment, 250,000. On the accessory after the fact, grand theft of motor vehicle, 50,000. Court date's gonna be April the 14th, 9 o'clock. No contact with the alleged victim or co-defendants.
10. The co-defendants are on the list, so you're going to call the unit. Step to your right to the T. When the green light comes on, sign.
Go on and say that they're not gonna make their bonds either.
State your name, sir.
Israel Silva.
Mr. Silva, you're fully court for aggravated assault with deadly weapon. You understand that charge?
Yes, sir.
I understand you've been given copies of paperwork, advised of your rights. Is that true?
Yes, sir.
Oh my gosh. Based on your application, you do qualify. I'm gonna go ahead and appoint the public defender to represent you. Any question about that?
He gave you a public defender.
Okay. Thank you, sir.
Yeah.
No history. He was asking me.
AR style rifle with bright nice green hardware.
Sir.
Nothing, Mr. Silva. Bond set at 50,000. No contact with alleged victim, no access to firearms. Court date's gonna be April 17th at 9 o'clock.
Step to your right to the T. When the green light comes on, step on the red X. State your name.
Albert Haygood.
Mr. Haygood, you're for the court charge of failing to register. Do you understand the charge?
I'm sorry, sir, I didn't hear you.
You're charged with failing to register.
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right. Based on your
Notice
application,
that-
do you qualify for a public defender? I'm going to appoint one. So you got an attorney now.
No, sir.
He just gave you one.
Okay,
Dude,
thank you.
deputy, criminal history.
Just the original.
Bond set at 5,000. Court date's April the 7th at 9 o'clock. Must register.
Step to your right to the T. When the green light comes on, sign. Next. Yes, sir. Red X. State your name.
Kyle Valerie.
There you go.
Mr. Valerie, before the court charge of robbery of firearm, kidnapping or false imprisonment of an adult, grand theft of a motor vehicle, possession of marijuana with intent to sell or distribute, and trafficking fentanyl. Do you understand those charges?
Not really, because I got robbed, so I don't know how I'm getting charged when I got robbed by the same person.
Yeah. Do you also get hit in the back of the head with a rifle?
I ain't get hit with no gun, but I got robbed, though.
So you just got rode around, just a fun ride. All right, Mr.
Whatever
Bellamy,
they want to call it.
I've been getting woken up for the last 4 nights trying to learn from this crowd. It's a sad day when you can't go to Bambi's and have a good time without getting robbed and picked up. It's a travesty. Did you come down here from Alabama too?
I'm not even from Alabama or Florida. I'm from Louisiana.
Oh, hell, yeah, that's worse. Deputy, criminal history on Mr. Ballard?
I got in trouble before, but that was years ago. I only come out here to see my daughter.
Okay.
I only come out here to see my daughter. The same person whoever was orchestrating all that. She set somebody up to rob me too.
Your daughter did?
Huh?
Your daughter said that?
You said what happened?
No, he's talking about the girl from the other day.
I'm talking about that girl with them funny colored eyes.
Oh,
Locally,
yeah.
21, there was carrying and concealed marijuana distribution, resisting. Louisiana 21, hit and run marijuana with intent.
And then I'm staying at somebody. I'm spending the night at somebody's house, and they saying something about some people. That's the judge right there.
Mm-hmm.
I'm spending the night at somebody's house, and they went in the house to come get me for whatever reason, but they got some pills in this person's house, and they charged me with the pills when I don't even stay over there.
They charge you with all the pills. That's brutal.
Yeah, huh? I don't know why. I'm not from out here. I don't even stay over there. That's not.
You don't get something. I mean, one's got nothing to do with the other. You agree with that? Just being from here don't have nothing to do with whether or not you did anything. People come here all the time and do stupid stuff. They do. It's.
I understand that.
Bay County, Florida. That's what happens. People would never do things in their own hometown. They come here and they do stupid stuff.
Yeah, not me though.
I'm just saying.
I'm trying to help. I'm trying to help the investigation.
Don't make nothing.
Yeah, but I'm trying to help the investigation. I ain't.
Well, it's always better. It's always better to be a witness than a defendant, right?
Right.
Okay. All right. So I've already appointed you a public defender, so you got an attorney now. The state has filed a nebia motion, which means that to make bond, you're going to have to provide proof that any funds that you put up as collateral comes from a legitimate source. No. All right. On the robbery with a firearm, bond's $500,000. The kidnapping is $500,000. The grand theft is $50,000. The marijuana with intent is $5,000. And the trafficking is $500,000. Random UAs. I'm granting the nebia motion. No contact directly, indirectly, or through a third party, alleged victim or co-defendants.
Step to your right to the T. When the green light comes on, sign for your copy. Next. Red X, sir, state your name.
Torres.
Mr. Torres, you're for the court, charged grand theft. Do you understand the charge?
Yes, sir.
Expensive air drivers. Golly Moses.
You know he was gonna say that.
I just can't get over it. It's insane.
I know. Yeah. Oh.
Oh. All right, man. I did. All right, man. I'm gonna put a $5,000 bond on this case. Court date's gonna be March 27th at 9 o'clock. No contact with the alleged victim. Good luck, sir.
Yeah, thank you, bro.
They're in the same room, so you're gonna have to take him and put him down there. We say 5,000 on him again?
5,000.
I did.
Next. Next. Gilliam. Red X, state your name.
Gilliam, for the court charge of robbery with firearm, kidnapping, false imprisonment, and grand theft of motor vehicle. Do you understand the charges?
Say it again, sir.
Do you understand what you've been charged with?
No, sir. Wait, yes, sir. Yes, sir. I see what they gave me on this paper. Yes, sir.
This all news to you?
Yes, sir. I I was talking to my wife and I turned myself in to really came up here to clear my name because I was wrongly accused with a group. And I understand the people I hang with, but I really just came up here to clear my name because I found out I had a warrant for my arrest.
Okay, good. Based on your application, you do qualify for the Service of Public Defender's Office. I'm going to go ahead and appoint the public defender to represent you. Any question about
that? No, sir.
Yeah, criminal history?
His has a lot of juvenile history. All of it's juvenile except for these, and that was 22 Karen Cassell, Defray, Grand Theft Auto, 21 burglary, no valid, less than 20, Grand Theft Auto again, and it goes back to 18 in juvenile.
All right, bonds 500,000 on the robbery, firearm, 500,000 on false imprisonment, 50,000 on the grand theft of an automobile. No contact with the co-defendant or alleged victim.
Step to your right to the T. When the green light comes on, sign. What's the court date, sir?
April 14th, right?
Can I get a bond?
14th at
Yeah.
9 o'clock.
Thank you. State your name.
Kylan Nolan.
Who is this?
Kylan Nolan.
Mr. Nolan, you're fully court charged robbery of firearm, kidnapping, false imprisonment, grand theft of a motor vehicle, firing a weapon or discharging a firearm from a vehicle, and firing into a moving vehicle. You understand the charges?
Yes, sir. Excuse me. Two of them were old charges or warrants.
They got waived up.
That I didn't know that I had.
Yeah, because they started off in juvenile court, didn't they?
Yeah, I think so.
Yeah.
But I didn't have a baby. I didn't have a job. I didn't have a baby. I didn't have a job, and I've been trying to get my life together until this came up.
Guess what? You just took a left turn.
I ain't even know this happened.
Okay, well, we'll sort all that out later. I've appointed a public defender to represent you, deputy criminal history.
1 second, sir. Go to that one right there for me. Yeah, go ahead. Trying to keep them separate because you ordered that.
I know.
His is all juvenile except for he had a burglary in Louisiana last year. Prior to that, 20 juvenile ag bats, 21 no valid less than 20 grand theft auto times 2 loitering and a grand theft auto and 19.
Robbery of firearms, 500,000, kidnapping, 500,000, grand theft of an automobile is 50,000. The juvenile waive up, discharge of a firearm from a vehicle is 25,000. And the missile into a dwelling or vehicle is 25,000. Court date's going to be April 14th at 9 o'clock. No contact with alleged victims or co-defendants.
Thank you. Step to your right.
You add all that all together?
I did.
How much?
It's a lot.
1,000,000. 1,000,001.
That's how
Step
much
on the
my
T.
bond is? Oh my God, man.
Step on the T. When the green T when the green light comes on, sign for your copy of it.
Baby.
Next. Red X, sir. State your name.
Justin Lilly.
Mr. Lilly, fully court charged child neglect, possession of meth with intent to sell or manufacture, possession less than 20 grams of marijuana, introduction of contraband into a detention facility, and paraphernalia. Do you understand those charges?
Yes, sir. Could we try to make this a low bond so I can get out? I gotta go to work on Monday.
I like a man that knows what he's asking for. You didn't ask for a fair bond. You didn't ask for a reasonable bond. You asked for a low bond. I admire that about you.
Please.
I'm not saying I'm going to do it, but
I understand myself.
based on your application, I find that you do qualify for I'm going to appoint the public defender to represent you.
Okay.
Yeah, on the street.
Tennessee, 21 FTA and a para. Locally, nothing new since 18. That was less than 20. Para controlled substance times 2 and 1 FTA and 20.
You don't show up for court.
I've been in no trouble though, sir. I'm not going nowhere. My kids and my wife are here. My wife and my kids are here. I'm going to show up. I promise.
Don't show up
I swear
for
to God.
court.
I will. My wife and my kids are here. I'll be here.
What's
Hey. Right there with that open door where he told you to go.
Oh, is that sir?
I don't know. She's distracted.
Please. Please, I got my kids. Please, I gotta get out of here.
I want to duck. I got to.
Right?
She made me duck. All right, on the child neglect, bonds 25,000. No contact with alleged victim. Possession of meth with intent is 25,000. Marijuana is 2,500. The introduction is 2,500. And the paraphernalia is 1,000. Random UAs, court date's gonna be April 7th at 9 o'clock. Good luck, sir.
Thank you.
Wait. Step to your right to the T. When the green light comes on, sign. Next. Red X, sir. State your name. It'll come on in a minute.
Carlos Wells.
Mr. Wells, before the court charged possession of meth with intent to sell or distribute, child neglect, possession of less 20 grams of marijuana, and paraphernalia. Do you understand the charges?
Yes, I did.
I understand you've been given copies of paperwork and advised of your rights. Is that true, sir?
Yes, sir.
Based on your application, if I find you do qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that? Deputy.
I'll give you a public defender. Nothing new since 22. That was possession of cocaine and para. 21, less than 20 para. VOPs through 23. 20 battery, grand theft auto resisting DWLSR. Goes back to 14.
Meth with intent is 25,000. Child neglect is 25,000. The marijuana is 2,500, and the paraphernalia is 1,000. Random UA's court date's going to be April 7th at 9 o'clock.
Step to your right to the T. When the green light comes on, sign.
That's right. I have those two back to back.
Yeah. Who hasn't woken up and wondered where their car was? Jada. Mr. Parker, how you doing, sir?
I'm good, sir.
Mr. Parker, you're before the court on violation of probation for what was originally assault. You've been ordered held without bond. Your court date's going to be March 13th at 9 o'clock. Good luck, sir.
Thanks, sir.
All right, step to your right to the T. When the light comes on, sign. Next. Red X, state your name.
Mr. Colson, before the court on violation of probation. You've been ordered held without bond. Your court date's going to be March 13th at 9 o'clock. Good luck.
Step to your right behind him. State your name. Next.
You said hell without mine?
Yep, till at least 13th is Wednesday. State your name.
Wendell Cooper.
Mr. Cooper, before the court on violation of probation for a domestic violence battery. You've been ordered held without bond. Your court date's going to be March 26th at 1:30.
All right, step behind him at the signature pad. Come on, Pope. State your name.
George Pope.
Mr. Pope, before the court on a violation of probation for battery in a jail facility. Been ordered held without bond. Your court date is April the 16th at 9 o'clock.
All right, you can step behind him, hon. Next. Red X. State your name.
Ryan Walker.
Mr. Walker, you're before the court on a violation of probation charge for driving license suspended or revoked. You got a suspended jail sentence apparently in front of Judge Dyer. So he's already held without bond. Your court date is Wednesday, March 13th, 9 o'clock.
How long?
I don't know.
Have a jail sentence? How long?
I don't know. You signed it, you would know.
How long does it say the jail sentence is, Judge?
No, I don't know. That's between you and Judge Dyer.
You go see him Wednesday. All right, step to your right to the T.
You agreed to deal with the devil to get out of jail on your first violation. So here we are again.
Next.
Next.
Yes, sir. Step on the red X. State your name.
Jalen Stuckey.
Mr. Stuckey, you fully court on a violation of probation for burglary, possession of a firearm in front of Judge Registry. You understand the charges?
You understand what you're charged with, the VOP?
The VOP, what? It was because of misdemeanor. Is there anything I just violated for the misdemeanor side?
What's your question?
I'm just in here on the VOP for technicals.
That's what you're here on
That's it?
today. Yes, it
Yes,
is.
sir. So what would be stopping me from getting a bond today, sir? This is my first violation, Judge, man.
Lord God
I just
Almighty.
seen you on the 26th. Yes, sir.
The register is order you held without bond. Your court date is April 16th at 9 o'clock.
April 16th?
Step behind him at the signature pad. Well, step on the T. Yep, when that light goes off and comes back on, you're gonna sign it. Next,
Yeah, that's true.
you probably get a copy of it. Next, red Xer, state your name.
Joseph Clayton.
What happened
Did
to,
Aaron bond out?
No, I'll get him in a second.
Mr. Clayton, you're full court with aggravated assault, theft, weapon, incident charge.
Can you say that again, sir?
Do you understand what you've been charged with?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
All right, sir. Based on your application, you make too much money to qualify for a public defender, but the law recognizes your financial situation may change, in which case you can reapply later. You also have the option to hire your own attorney or represent yourself. Any question about these options?
No, sir.
Deputy, criminal history?
No history.
Onset at 50,000. No contact with the alleged victim, directly, indirectly, or through a third party. No access to firearms. Court date's April 17th at 9 o'clock.
Step on the T. When the green light comes on, sign. Next. Wait for the light to come on. Next. Red Xer, state your name.
Aaron Jones. Mr. Sean, you're fully court on a violation of probation for what was originally a driving license suspended revoked. In that case, you've been set bond at 15,000. Your court date is March 26th at 1:30.
Step behind Tim at the signature pad. Next. Red Xer, state your name.
Mr. Alex Bro.
Mr. Bra, you're fully court charged disorderly conduct by brawling,
Yes, sir.
resisting also without violence. You understand those charges?
What, say that again?
You understand what you've been charged with?
Yes, sir. Yes, I did.
Based on your application, if I do qualify, I'm going to go ahead and appoint the public defender. They have an attorney now. Deputy, criminal history, Mr. Bra?
So pre-trial release with you for criminal mischief and 2 batteries.
What was, did you ask me something?
He can hear you.
I didn't really ask him.
What do you want to tell me?
No, I had nothing to say. I was accepting the charges. Sorry.
You got a case number now?
25,684 MM.
All right, sir. On the disorderly conduct, bond's 2,500. The resisting is 2,500. Your court date's gonna be March 10th at 1 o'clock. I'm revoking release in 25,604. You can get all these things resolved Monday.
Everything resolved Monday, sort of stuff.
Yeah.
Step to your right to the T. When the green light comes on, sign. That's a wrap, sir.
It's my 2 weeks.
It's your 1 week. Stop it.
Dyer? Judge Dyer's got this weekend because turkey season opens next weekend, so he won't be here on that weekend. Ms. Fanbro, you're gonna miss me for 6 weeks.
Well, that's it for Van. Now we're zooming back up to Michigan. This is Wayne County. We're going to start with Judge DeSanto with a very disagreeable lawyer. Move over to Judge Washington. This actually happened on the same day, ladies and gentlemen. 2 disagreeable people on the same day. Ladies and gentlemen, we're getting started right now.
Clerk, I have Daniel Timph.
Okay, excuse me, let's go off the record. Counsel, when I'm trying to call a case on the record, I can't have you just interjecting and interrupting the record. What is it you indicated, counsel?
I'm here on Daniel Timpf, Judge, for the third time. And all we're going to do is ask for an exam date.
Have you already spoken to the prosecutor today?
I don't think I need to talk to a prosecutor to get an exam date unless you want me to agree to a date with him. That's fine.
Yes, because the prosecutor has the file, and we don't know when the file is ready until after there's been communication between the attorneys, and then he sends that in with what's happening. So we're going to put you in a breakout room with Mr. Matherly.
Thank you.
And then next time, counsel, if you can just wait until we're asking for something, we're going to check people in so that it's not interrupting the record, please.
Okay, Judge. I just wish, that your court answered their phones.
Counsel, as I stated before, we are severely understaffed. We have people that are out sick. So
Judge, there's no reason why for 4 days, you calling from 8:30 to 4:30, that nobody answers your phone in any department that I dial. So I have an issue with that. Yes.
Mr. Margolis, again, I take exception to your continuing interruption when I'm speaking. As I've stated, it is most effective to send in an email to communicate with the court, because we have one of my staff members that's here in the courtroom. We have others that are out ill. So that is what we're dealing with right now, counsel. So as I stated before, the most effective way to communicate, to find out a question, to ask anything, is to send in an email.
I know, Judge. The last email I sent took me 2 days to get the answer. And after the court told me that they were calling me back. So respect goes 2 ways, Judge, with your court. So yes, I try to be respectful, and I will be respectful in the future.
Well, I will check into that to see, because typically it's only within a couple of hours. So I will check that to see what happened in that regard.
Well, should I stay on Zoom or should I call back? Because I have 4 other matters this morning.
We're putting you in a breakout room with Mr. Matherly, counsel.
And then do you have him on Zoom from the prison or not?
Your client
or
is
do we
right
not
here.
need him?
Would you like to speak to your client?
Well, just put me in the breakout room with the prosecutor, Judge. Thank you.
I'm sorry. Well, I'm sorry, Mr. Willis. You're telling me to just put you in a breakout room with the prosecutor. Is that what you're telling me?
Yes, I've already talked to my client. We're ready to go. It's just a matter of getting a date with the prosecutor.
So he's going to tell me what to do. We're putting you in a breakout room with Mr. Matherly.
And that's what you said. And I'm ready. I'm waiting.
We are on the record. We're recalling the matter of Daniel Timpf. And counsel, your appearance, please.
Elliot Margolis, P28078, on behalf of Daniel Timpf, Judge.
Okay, we just need to move him back into the main session here. Counsel, can you jump back in there so that you, on your device, and let him know that he has to join we've requested for him to join the main session.
I can't understand you again, Judge. Your voice blends into, for some reason, you're the only judge that I cannot understand, and it's not your fault, but.
Can you please jump back into the breakout room you were in with your client and request him to join the main session?
I did tell him to join back in, but he didn't have any way of doing it. And I told him to tell them to get him back into the courtroom. I've already told him that, Judge. I'll waive his appearance for this purpose. He knows I'm requesting a preliminary examination.
Okay. All right, we can set this for exam. Are you looking for next week, counsel?
Next week, Yeah, does Thursday work for the court?
Yes, it has to be a Thursday. Does that work for us, Ellie?
Yes.
At what time?
How late in the day are you scheduling that day? Because that's when you're off 8 to 1.
Yeah, can we do 2:30?
Yeah.
Okay, 2:30,
At what time?
2:30,
2 o'clock in the afternoon?
2:30 PM,
2:50?
2:30, 30.
2:30. Okay, I'm sorry. I will be there at 2:30 on Thursday, the 13th, Judge.
Okay, witness and exhibit list by March 10th. Bond and conditions are continued. Mr.
Thank
Tim, Mr. Tim's back in the session. Mr. Tim,
Okay.
can
Thank you,
please-
Judge. He's going to need to be writted. He's going to need to be writted from the jail. From prison, I should say.
Counsel, I was still talking. I was saying that Mr. Timpf is back in the main session. Mr. Timpf, please unmute. Mr. Timpf, I need you to hit unmute on your device. Can you hit unmute?
It is unmuted.
Now it's unmuted, yes. Now it's unmuted.
I've never hit the button, so it wasn't on my end.
No, sir, when it moves you back and forth between the breakout rooms, I think Zoom automatically mutes you. So.
Okay, I'm sorry.
No, you're fine. There's nothing to apologize for. All right. So we set this matter for preliminary examination on March 13th at 2:30 PM. So next Thursday, sir. And counsel, yes, I'm very much aware the court has to send a writ to the prison so that he can be present. Bond and conditions will be continued.
So March
Anything else?
13th?
Thank you, Judge.
Yes.
Thank you.
March 13th. All right, thank you, Your Honor.
You're welcome. Have a good day. Miss Wilkie back in?
Yeah, she's.
Okay, perfect. Okay.
Are you ready now, Mr. Mansour?
Yes, Your Honor. Thank you for that opportunity.
All right, the court will recall the case of the State of Michigan versus Kelsey Salter, case number 24S00225.
Tiffany Woods for the people.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Miss Kelsey Salter. Kelsey, can you unmute and state your name for the judge?
Kelsey Nicole Salter.
Thank you. All right, this matter is scheduled for a jury selection tomorrow, and I understand that there are some issues going on that we need to make a record of, and the court makes some rulings.
Yes, Your Honor, that is correct. The Washtenaw County Public Defender's Office is currently appointed on the matter. As of right now, I know Ms. Salter is working on getting private counsel to represent her going forward. Outside of that, Your Honor, I am ready to proceed with jury selection and trial. I've submitted jury instructions, witness list, exhibit list, and
And I just got the discovery packet yesterday. You haven't even talked to my witness or anything. You have not been helping me. All you threatening me with is jail time.
Ms. Salter, if you keep speaking out of turn, ma'am, you're going to be held in contempt of court. So you need to stop right now.
I didn't know I couldn't talk. I thought that was the purpose of me logging on. I apologize.
Please continue, Mr. Mansour, if there's anything else you needed to say.
Your Honor, the only thing left I need to say is I believe there's a breakdown in communications here. Me and Ms. Salter are not communicating well with each other. I believe the trust has been broken. She has indicated she does not want me to represent her going forward. She's also indicated to me that she has hired a new attorney and that she does not want pretty much anything to do with me. And so other than that, I am ready to go with jury selection and jury trial, but I don't think I can adequately represent her without any trust.
Ms. Salter, you are here now, and now it is your turn to speak. What is it that you would like to say about this before you start talking? We're scheduled for trial tomorrow, any attorney that shows up tomorrow will be going to trial. Where are you with this?
He keep threatening me with jail time, and I'm telling him I didn't do it. Like, why is he not trying to defend me or even look into my case to find out? He haven't done anything with my case. I just got the discovery packet like 2 days ago. Even Miss Taylor said the same thing. Like, why is that okay? Oh, he threatened me. The judge is not like that. She's gonna lock you up if you don't take the plea. Like, why is that okay? I'm scared. Like, I don't get it.
Ma'am, I don't know how else to tell you, but tomorrow is your trial date, and I'm trying to figure out whether you are going to have new counsel or whether you're going to trial with Mr. Mansour.
I'm meeting with her tomorrow to fill out all my paperwork, but she's agreed to take on my case.
We're going to trial. We're picking a jury tomorrow morning for jury selection. So you can't hire someone on the day of your jury selection.
I've been talking about this for the past. This just didn't happen.
I'm not going to argue with you.
Wow, this is crazy. So you basically telling me I don't have the right to hire my own lawyer because I'm being told something else by Miss Taylor that I'm allowed to have my own lawyer.
What I'm telling you and very clearly telling you is tomorrow morning we're going to jury selection. And this case has been going on since October of 2024. You've had plenty of opportunity to hire your own counsel, and you have not done that.
Ma'am, he didn't make, okay. It's like, why are you doing this to me? Like, what did I do wrong? I didn't do the crime and he's not trying to help me. I'm telling you, he's not trying to help me. All he threatening me with is you gonna lock me up. Like, why is that okay?
Well, if you yell at me one more time, you're gonna get locked up for contempt of court.
I'm not even yelling though. Like, that's you. Okay, I apologize. What?
Your behavior in court today is very disturbing.
Ma'am, I am so frustrated. I've been reaching out to Mr. Mansour trying to get so much help since my case. You can look at our text messages. Even Miss Taylor said that he's not responding to anything I'm asking about my case or even trying to help me. Like, I apologize. I'm not being rude to you. I'm frustrated. I haven't even had no sleep all week. Like, you could talk to my therapist. I'm going through it. I don't know nothing about this case and he is not helping me. You talking about I'm being rude? I haven't even said nothing rude or disrespectful. I'm frustrated.
You are still yelling, and I've asked you a number of times to stop it. And that's interesting because you're here for disturbing the peace. And yet you're in the courtroom disturbing the whole demeanor of the court.
Okay, I thought that was, he called me and told me to log on and explain to you my situation. So I thought that's what I was doing. Like, I didn't know I was doing anything wrong.
You are doing something wrong because you keep yelling. So why is it that you're waiting until your day of trial to actually hire this attorney? Why is the attorney not today?
The way he explained it to me that tomorrow is just a jury, you're picking a jury and the trial is not tomorrow. This is all new to me. I didn't know that that's how this worked.
So tomorrow you'll be picking your jury with Mr. Mansour then if you don't have your attorney by then.
Okay, but that was the purpose of her asking him to get it adjourned because she has a case tomorrow that she couldn't step in on.
It's not going to be adjourned.
Okay, ma'am, that's fine. That's fine. I appreciate you. So I'm forced to deal with a lawyer that I'm like, I cannot even believe this is happening to me.
All right, well, I've told you where you are. You can choose an attorney who can show up here with you before that date, or you can go to jury selection with Mr. Mansour in the morning.
Okay, thank you. Am I all done here?
No, you're not.
I have a question. So it's okay that I'm just now getting my discovery packet? Because I've been asking about everything about my case and I'm just now finding out anything this week.
Mr. Mansour, is it true that she just received her discovery packet?
Your Honor.
Like, isn't that malpractice?
Ma'am, I've told you, if you say one more thing out of turn, you're going to be held in contempt today. Do you understand me?
Yes, ma'am.
One more thing, and I'm not joking. And the first thing you're going to get is 30 days. So stop it. Mr. Mansour, is it true, sir, that she just got her discovery packet?
Your Honor, it is our office's policy. If a client requests their discovery, we send it over. She has not requested her discovery until Monday of this week. She requested it Monday via email. I let her know, if you want your discovery, you have to request it through email or writing. She did that promptly on Monday. She sent an email requesting discovery. We sent the discovery immediately the same day.
Thank you so much.
And Your Honor, I have gone through the police report with her. I have gone through all the discovery with her. I have done my due diligence with her as I do every single client I represent. Miss Salter has made remarks towards me that I'm not a real lawyer, that I'm not after her best interest, that I told her specifically to plead or she will go to jail, when none of that would ever be true. I would never do that. So and Your Honor, yesterday, she also mentioned that she would like to call our office to write a report on me and whatnot. So this is where we are with this relationship right now. And when I try to, respond back to her, she would yell so loud that I can't even get a word in. And this is how it's been going. So
Thank you, Mr. Mansour. Given the behavior and the way she's treating me today, I fully believe that to be the truth.
Princess, stop.
I'm sorry, what did you say?
I was talking to my daughter. I apologize.
Please. Well, this is about an incident in Tim Hortons.
Are you asking me, ma'am?
No, I'm not, ma'am.
I'm sorry.
Yeah. Yes, Judge.
And you have your complaining witness in this case?
Judge, the victim is a child. He's a six-year-old boy, his mother. And then there's some other witnesses that, I haven't gotten subpoenas to yet because I don't have the trial date confirmed. I know that my OIC is not available on that date. He is not even going to be in the state. I believe he's out on vacation on the 21st. So
the child that she allegedly bumped into, the victim that she allegedly bumped into is a child?
yes. And the mother was present as well, so they would both be testifying.
The allegation she was yelling that she was gonna beat the mother's butt or the child's butt over a parking spot?
I believe she was upset because the child and the mother weren't moving out of the parking spot quick enough. So she was beeping their horn when they went into the store to stand in line. It's alleged that the defendant went in, was trying to get through the line and then hip checked the 6-year-old, basically, wanting to get him out of the way so she could go get her an online order that she had placed previously. And then there was some disturbance inside the Hortons because the mom wasn't happy when she saw that Miss Salter had assaulted her son and was acting out that way.
Okay. So are you requesting that the public defender's office be removed from your case, Ms. Salter?
Yes, ma'am.
Do you have a position on the motion by the defendant to withdraw? Because the PD says they can proceed. The defendant does not want him as a part of her case. Do you have a position on that, Ms. Woods?
Judge, I take no position. I will leave that up to the court.
The PD is going to be allowed to withdraw due to a breakdown in the attorney-client relationship. What I'm going to do is request that a new attorney be appointed unless she hires her own so that we can be able to proceed with this case. Ma'am, you're free to hire whoever you want to hire in the interim time period. Do we have any testing in this case?
I'm sorry, Judge.
It doesn't appear that there's any testing going on in this case.
Yeah, I don't believe that there was any alcohol or drugs alleged in the police report. That could be why she was not put on testing.
Ms. Salter's behavior towards her attorney, towards the court, is extremely disturbing. I can't believe that anybody would behave the way she behaves unless something is going on with her. Ma'am, you need to test within 24 hours.
Where do I go test that, ma'am? I live an hour and a half away. I don't know nothing about Washtenaw County.
You need to go test at Community Corrections.
Okay, and where is that?
Can you give me the address, please?
So I'm being forced to go test because you saying I have attitude because I'm frustrated because I'm not getting any help? Like, what did I say wrong? I'm so confused. What did I even do? I see a therapist every month that I have to drug test for every month, ma'am. I'm not doing anything illegal. I'm a single parent.
Can I have the address?
Yeah, I was gonna put it, I'm sorry, she's still talking to you, so I have to
Okay.
put her in a team, but it's 4101.
4101 Washtenaw, ma'am. You need to go there and test within 24 hours.
Okay, am I able to do that tomorrow? Because I have to come out there anyway.
Ma'am, I just said you need to do that within 24 hours.
I cannot believe this is happening.
I'm sorry. All right, and the cost is $12. Is that for both tests? All right, total is 27, ma'am. You need to test within that 24 hours, ma'am. I'm gonna put this on for another pretrial date. I'll make that March 27th, 2025 at 10 o'clock a.m. Ma'am, you need to have your own counsel on that date. If you don't have one, the new attorney will reach out to you a couple of days before them that's been appointed. Do you understand?
Okay. Yes, ma'am.
We'll see you here on March 27th. If you
Thank
don't,
you.
if you don't go test, I will issue a bench warrant.
Ma'am, I'll be there.
Thank you.
Thank you.
Trial will be canceled.
And that's how that happened. You know, that'll be more interesting later. But I mean, acting like that when you're there for disturbing the peace, it's crazy. Hey, next, we're going to Fulton County, Georgia with Judge McBurney and a sick guy who steals dogs and murders people. We got a little bit of news clips to head it up. Ladies and gentlemen, starting right now.
He was walking his dog, and I guess somebody decided that they wanted to take him out.
But first, the family of an Atlanta man is mourning after someone shot and killed him while he was walking his dog. Tonight, police are trying to search for that killer. That's where we start tonight on News Edge at 11. I'm Christine Spiro.
New at 6, another man is behind bars tonight in connection with the shooting death of a man who was walking his dog in southwest Atlanta. The DeKalb County Sheriff's Office says deputies arrested Ricky Pierce on Friday. Pierce faces charges including murder, aggravated assault, armed robbery, and more. Brandon Baker was also arrested back in April. He faces similar charges. Samuel Harris was shot and killed on Mitchell Street Southwest just after 8 p.m. back on February 5th. His dog Tequila, seen there, was stolen during that incident. Leah Harris, his wife of 15 years, described him as a family man with a calm spirit who had lived here in Georgia for 30 years. Authorities are still investigating what happened that night. If you know anything in this case, you're asked to call Atlanta police.
Good afternoon, Mr. Pierce.
Good afternoon.
How are you?
Fine.
Good. I'm hanging in. That's been a long day, but I'm sure it's been a long day for you as well. Whoop. Let's get your stuff all situated.
Y'all sit down, man. Y'all sit down.
Okay, well, you've waved to him, but this isn't a place where we have that kind of conversation. You bet. Mr. Pierce, when we were last together, we had a conversation about representation, and you told me that you wanted to represent yourself. You didn't want a lawyer appointed, and you weren't going to be hiring a lawyer. And I said, we can have that conversation. That's an extended conversation, judge and defendant. And I'm ready to do that so that we can move your case forward. Otherwise, you're kind of stuck until we clear that hurdle. You have a right to represent yourself, but I need to make sure that you are knowingly invoking that right and intelligently, which is not me telling you you're not intelligent. I just need to make sure you understand the consequences of self-representation. So that's what I was hoping we could get through today. But I always want to start by saying what is on your agenda, so we can see if there's anything else.
I'm American State National, and I can't be represented by no attorney. But I have a lot of issues with me being a national that I wanted to address. You said you were going to let me hear me. You're going to let me address all my issues last time I was here about me being.
Well, I did say that, but I said if you're going to address issues, I need to make sure you're representing yourself. Okay, but if we're going to do that, we have to have my conversation first. I'm required by law and by the Constitution to go through a few things to make sure it's appropriate for you to represent yourself. So you can want to do it, but I got to make sure it's appropriate to let you do it. I'll just give you an example. Let's say that you were deaf. That might make self-representation kind of complicated. You're not deaf, and so you can hear me and I can hear you. But I need to ask you a bunch of questions about your background and make sure you understand the consequences of being your own lawyer. If you assure me that you got it and getting all those things, you want to represent yourself, I have to give you that right, and I will. And then you can share with me what your issues are. Okay? You ready to work it that way?
Yes, sir.
Excellent. Let me get one thing here and we can get started. All right, Mr. Pierce, please tell me how old you are.
41 years old.
How far did you go in school?
11th grade.
All right. Did you ever get your GED?
Yes, sir.
When did you get your GED?
2017.
Excellent. Are you able to read English?
Yes, sir.
I know you can write in English because I got these and you actually mailed me something that
Yeah, I wrote you a letter.
about 200 pages long. All right, so you can read and write. And you can speak English. Have you ever worked before?
Yes, I had several jobs.
Tell me what kind of work you've done before.
I worked for Dollar Tree when I got arrested. I worked there for Airmark. I worked there for the Move Theater in North Cap. I have my own landscaping business. I have my own record label. I worked at McDonald's, Burger King.
You've had a bunch of jobs. Got it. All right, that's helpful to know. I appreciate you sharing that. Have you gone to law school?
I haven't gone to law school, but I have practiced, not practiced, I've been studying law.
You've been studying the law. Tell me how you've studied that.
Just reading, researching different case laws, sending out different statutes and codes and things of that nature.
Sure. Has all of your legal study been while you've been in jail, or have you also done legal study when you were out?
Both in and out.
Okay, got it. Have you ever watched an entire criminal trial before, start to finish?
I done been to trial before.
So you've watched one then?
Yes.
Okay. What was that trial about?
Armed robbery, the 10 years I just did for armed robbery.
So you were charged with armed robbery.
Yeah.
And that case went to trial.
Yes, sir.
So you were there from jury selection all the way through verdict.
To closing argument. I stopped before closing arguments and took 10 years.
Oh, you pled guilty.
Yeah,
Got
I
it.
tried right before they were finna come out for closing argument.
So you've seen 95% of a trial.
Yes, sir.
All right. You ever watched a trial on TV?
Yes, sir.
What kind of trial?
What that movie that's so called? Law and Order.
Okay, you've seen that kind of stuff. So you've seen the made for TV stuff.
Right.
But you've been in a real one. You were a participant in a real trial.
Yes, sir.
How long ago was that trial?
2016.
Where?
Here.
Fulton County.
Yes, sir.
Who was your lawyer?
Kevin Farm. He's a judge now.
He is. That's
Yeah.
a small world.
Yeah.
All right. Have you ever represented yourself in a criminal or a civil case before?
No, I haven't.
This would be your first time.
Yes, sir.
Got it. Have you ever gone to a doctor or a counselor to get treatment for any mental health issue?
No, sir.
Depression or bipolar or anything?
No, sir.
Okay. Tell me why you think you would do a better job representing yourself than a trained lawyer who went to law school and has done trials before would do.
Because by me being a Mr. National, a lawyer only subject me to the jurisdiction.
So hold on 1 second. Yeah, you got it. So the court reporter needs to be able to take down what you're saying. What you're saying is important. So just don't rattle the change, and then she'll be better able to hear you. So you were telling me by being an American
State national, and by me being a national, I can't be represented by an attorney because attorney automatically subject me to the court's jurisdiction.
Okay. So my question was a little different. I hear you. But my question is, why do you think you would do a better job than a lawyer? It sounds like you may think a lawyer would do a better job, but you don't want a lawyer because you're worried that would subject you to the jurisdiction of this court.
I know for a fact it'll subject me to the, because a lawyer is as an officer of the court, and by them being an officer of the court, it automatically subject me to the court's jurisdiction.
Okay, well, indulge me for a minute and assume, you may think I'm wrong, but assume that I've decided that you are subject to the jurisdiction of the court. And you say, Judge, you're wrong. Okay, but I get to make the decision initially, and then you go to the Court of Appeals and they'll say McBurney was right, McBurney was wrong. But if I've decided that this court has jurisdiction over you and this case and your co-defendant, do you want me to appoint you a lawyer because you're stuck here anyway, or you still want to represent yourself?
I still want to represent myself because I'm not under the court jurisdiction.
No chains.
Okay, my bad. My apologies. I'm not under the court jurisdiction, and I've been studying it long enough. Almost my whole family is nationals, and we know pretty much a lot about it, and we know for a fact the only way I could be subjected to a court jurisdiction is through a lawyer, because the birth certificate is a void contract, and through that contract, the birth certificate contract is what makes me subjected to the court jurisdiction.
Okay. I'm gonna stop you again, not because I'm disagreeing with you. I am disagreeing with you, but we don't need to resolve that right now. I want to keep going with the discussion about representation. Before I get to the next question about the consequences of self-representation, if we fast forward and play this out, eventually you are either going to be pleading guilty in this case or you're going to trial. You're going to disagree about jurisdiction. I'm going to be very respectful and say, you know what? I hear you, Mr. Pierce, and you don't think I have jurisdiction or this court has jurisdiction over you. And I may be wrong about that, but we're still moving forward. Here comes a jury. We're going to do the trial. And so we'll go through that whole process. And I may be told I'm wrong by the Supreme Court, and then I'll have to fix that, and I will fix it. But there'll be this trial. You're going to want to represent yourself, even though we're going forward with it.
Yes.
Okay. Do you know what you're charged with in the indictment?
No, I haven't had, I know what I'm charged, but I haven't had nobody come talk to me about nothing. I don't know what's going on. I don't know.
Well, that's because you said you don't want a lawyer. And so this is what we're getting into. No one's going to come talk to you about what's going on. I'll make sure you get the discovery, the paperwork in the case.
And when would I?
It's complicated. We can get you the paper stuff pretty soon. But if I'm making this up, I don't know what's in the case. But if there's video, let's say there's surveillance video, I can't give you that at the jail. It's on a disc. What are you going to do with a disc at the jail? You can't watch that. You don't have a way to watch that.
And, I would be signing a private investigator too, right? By me representing myself?
Nope. You don't get an
How would
investigator.
I do my investigations and this part of the process?
Well, we're going to talk about that, but you don't, I mean, that's a reason to say, you know what, I will take a lawyer because that lawyer will have an investigator and that investigator.
But can I hire my own private investigator?
Well, with your money, if you got money for it, you can hire anyone you want. But I won't be providing you money to go hire an investigator because you're saying I'm handling it myself. I got this. Mr. Pierce has it, which means your family would be, they could be helping you or an investigator or something like that. Or there may be some way, and I can't teach you how to do it, where you could petition to get funds for an investigator, but that's not for today. One of the consequences of representing yourself is there isn't someone who comes and sits down with you and say, let's look at this discovery. Man, the way the police handled that looks like that's a problem to me. I've been a lawyer for 20 years. I've never seen a police officer do that. That's something a lawyer could tell you after he or she reviewed all the discovery. And you won't get you're not a dummy. You could look at it and say, hey, this looks suspect, but you'd be making that decision without a lawyer helping you think about it if you represent yourself. Do you understand that?
Yes, sir.
Okay. But you seem concerned that someone hasn't already come to the jail to talk to you about what's in the indictment.
I'm not concerned. I wasn't informed on it. I know I was supposed to get a discovery package at least, or
not yet.
Report an indictment or something.
You will get it if in the end you convince me that I should let you represent yourself, then you will get all that stuff. But no one should have given you anything yet because we're on hold. Is he going to have a lawyer? Then we give the discovery to the lawyer who works with you on that. Or is he representing himself? Then we give the discovery to Mr. Pierce. And right now you're saying, I want to represent myself. And if we get through this conversation, then you'll start getting discovery. Let me tell you what you're charged with in the indictment. Count 1 charges you with murder, and it alleges that you and Mr. Baker shot and killed Samuel Curtis Harris Jr. That's count 1. Counts 2, 3, 4, 5, and 6 are all, and 7 and 8 are all what we call felony murder, which is you and Mr. Baker caused the death of Mr. Harris by being involved in a different crime: attempted robbery, armed robbery, aggravated assault, being a convicted felon, and having a firearm. Although that's just Brandon Baker. Brandon Baker apparently was a convicted felon at the time of this murder, and the murder was in February of last year. Oh, you are too. There you are. So you had a felony conviction as well. You and Mr. Baker are charged with attempted robbery, and the allegation is, and again, these are just allegations. It's not proof of anything, but it's letting you know what you're charged with and what you'll need to defend against.
Okay.
But the attempted robbery allegation is that in February of 2024, you and Mr. Baker approached Samuel Curtis Harris Jr. on foot on Mitchell Street, right near here, with the intent to take his property. Count 10 charges you and Mr. Baker with armed robbery, saying, in fact, by using a gun, you took his property. In fact, what you took from him was a firearm. Count 11 charges you both with aggravated assault for shooting Mr. Harris. 12 is possessing a gun in connection with these crimes that I talked about. Same with 13. 14 is just Mr. Baker. 15 is you. And it says that on that date, you had a firearm, but you were a convicted felon because back in 2010, you got convicted of something in Clayton County. And also, you got convicted of something here in Fulton County in 2016. I guess that's your robbery you were talking about.
Yeah.
So the thrust of it is, the allegation is you and Mr. Baker robbed Mr. Harris and shot him, and he died as a result of that. That's what you're charged with. Today is not the day to say, I didn't do it, it was self-defense, I wasn't there. That's your defense for another time. That's what you're charged with. So,
Because I have it now?
pardon me?
How many counts I have it now?
It is,
Because I came here having 6 charges.
it's about 12 charges, but a lot of them overlap. 1 count of murder, several felony murder counts, because each of those other things I mentioned, the attempted robbery, the armed robbery, the aggravated assault, that creates a felony murder count. And then you've got a couple charges, all for possessing the same gun, but because of your criminal history, it can be charged in different ways.
But they got me charged with 3 different possession charges?
1 for possession of a firearm during the commission of a felony, and then 2 possession of a firearm by convicted felon, because you have a serious violent felony, your armed robbery, that leads to 1 type of possession charge, and the other, you've got this escape conviction out of Clayton, and that supports a different type of charge for possession.
And what that charge is?
It's possession of a firearm by a convicted felon, but it's a different type of convicted
I
felon.
got 2 possession of firearms.
You do? Yep. And those may not be good charges. I don't know. That's what you would talk to your lawyer about, or that you'd research on your own if you're representing yourself.
All right.
All right. Do you understand what the penalties are for these charges?
Yes.
You understand that for this murder charge, you could be sentenced all the way up to life without parole, meaning you would die in prison.
Yes.
Same with all the felony murders.
Yes.
You understand that they'd all merge. You can't get more than 1 life sentence for the murders.
Say it again?
You cannot get more than 1 life sentence for the murders. You understand that? They'd all merge together. But depending on how the case played out, armed robbery also, you could be sentenced up to life in prison. You understand that?
Right.
Okay. And then the other offenses, they're lower sentences, but still serious. But the big one is murder with the possibility, not the guarantee, but the possibility of life or life without parole. You understand that?
Yes.
Okay. Are you a U.S. citizen?
Yes.
Do you understand that if
I'm not a United States citizen.
well, I'm not trying to trick you. Were you born in the United States?
I'm not a United States citizen. I'm a American State national.
Okay. Tell me where you were born.
I was born at Greater Hospital.
All right, a Grady baby. That's all I need to know. There are a bunch of questions I can skip if you were born at Grady Hospital. If I decide that it is appropriate for you to represent yourself, do you understand that you don't get to change your mind partway through the trial?
What you mean?
Well, here's an example. In your armed robbery trial, you were able towards the very end to say, you know what, I want to plead guilty. I want to switch it up. I'm going to plead. Let's take this away from the jury. If you go to trial as your own lawyer and we get partway through and you realize, dang, this is harder than I thought. I don't really know what I'm doing. You don't get a call, a timeout and say, Judge, find me a lawyer.
Oh, yeah.
If we start representing yourself, we finish representing yourself. Start to finish, you understand?
Okay, so if I represent myself, later on down, I can't have my family hire me a lawyer.
That's different. That's different. I wouldn't appoint a lawyer.
Okay.
You could bring in a hired lawyer whenever you want, knowing that if we're in the middle of trial, you could bring someone in, but we're not going to pause the trial. That person would have to jump down next to you and say, I'm ready to go. That person couldn't say, well, I need a week to get ready. But you'd be telling a lawyer, this is a strange assignment. You're going to come represent Mr. Pierce, and he's actually on day 2 of the trial. But some lawyers might be willing to do that. So yes, your family could hire a lawyer tomorrow, next month, next week, next year. Hopefully we'll be done with your case before then. But what you could not do in the middle of trial is say, Judge, I quit. You need to go get me a lawyer. Understand? Okay. Do you understand that in almost every instance, self-representation, you being your own lawyer, is a bad idea?
That's personal opinion, right?
It is a personal opinion. I'm giving you my opinion. I think it's a bad idea.
Why?
Well, I'm about to get to that. Do you understand that if you represent yourself, you are not entitled to any special treatment? There's not a Mr. Pierce rule like, hey, he doesn't know this rule. I'm not going to apply the hearsay rules to him because he doesn't know what hearsay is. Do you understand that? Whatever rules apply to the state, and if you had a lawyer, your lawyer, they're going to be the same rules for you.
Understood.
So if you are asking questions of a witness and you really, really, really want to get this exhibit in, Judge, I need to let the jury see this. If you don't know what questions you're supposed to ask to get it in, I don't say, ask these 3 questions. You got to figure it out on your own. And if you can't, then this doesn't come in as evidence. You understand that?
I thought you were supposed to admit the evidence before you start trial.
Well, sometimes it works that way, sometimes it doesn't. It can work that way, but sometimes in the middle of trial, like, hey, you know what? I want to admit this now. But you don't get to ask me questions about how do I do this thing.
Oh, yeah.
If there's an objection and I sustain it, and you look kind of confused, you're just going to stay confused. I don't take a time out, have the jury leave the room and say, here are the 3 things you need to do to get this piece of evidence in. You understand that?
Yes.
That's one of the reasons why I think it's a bad idea, because I know you're smart and I know you've been doing some legal research, but I also know that you're not a trial lawyer. And so you might not know how to get something in evidence because you don't know which questions to ask, but you're aware of that. You know that's the rules. Do you understand, Mr. Pierce, that by choosing to represent yourself, you may miss possible defenses, legal arguments that a lawyer could make on your behalf to try to convince the jury to find you not guilty? Understand that?
Yes.
Yes? Okay. Do you understand that anytime that you fail to make what would be a valid objection, let's say the prosecutor is asking a leading question, and if you objected, I'd sustain it. If you fail to object, that evidence is coming in, and you don't get on appeal, say, wait, that evidence came in. Because if someone doesn't object, that's not anything that can ever be appealed. Do you understand that?
Yeah.
Okay. Do you understand that I will not be making objections on your behalf? I may be thinking, this prosecutor is breaking every rule in the book with these questions, but they're rules of evidence. And it's not my job to hit the buzzer and say, that's not a fair question. It's your job to hit the buzzer and say, I object. You understand that?
Yes, sir.
And I won't give you a little signal like a wink saying, hey, now's the time to object. It's you're on your own, sink or swim. You understand that?
Understood.
Okay. Do you understand that unless you take the stand and testify, none of the words that you say to the jury will be evidence in the case?
What you mean?
So lawyers are, you saw your trial. You said, hey, it ended before closings. That means you saw openings, opening statement. Then when the prosecutor got up and said, Pierce is a bad man, he did an armed robbery, you'll hear the evidence, and he held a gun to someone, whatever they thought the evidence would be. None of that is evidence. All of that is the lawyer talking, saying, here's what you may hear. You'd be free to give an opening too. And your opening might be, I wasn't there. It was all Mr. Baker. You're going to hear evidence that I was in Louisiana when this crime happened. That's not evidence that you were in Louisiana. That's just you talking to the jury. And I'll be telling the jury that nothing that you say when you're giving your opening or that the prosecutor says while she's giving her opening is evidence. It's just some guidelines that the jurors could choose to follow as they're thinking about what the case is about. The only way you would get evidence in is if you choose to testify or if you figure out how to admit exhibits.
Question.
Yeah.
What's the difference from me starting an open argument and a lawyer starting an open argument? It'll be admitted evidence if a lawyer start an open argument.
It's not. Nope. I tell the jury before we start the trial that you're going to hear from, if you represent yourself, I won't say the lawyer, I'll say you're here from both sides. You're going to hear from both sides an opening statement. That's not evidence. It is a preview of what each side thinks the case is about, but it's not evidence. And you didn't get to hear this because you pled out before then, but I would say, as would any judge before closing arguments, you're about to hear closing arguments. These are not evidence. These are arguments from both sides saying, here's what the evidence showed, or here's what the evidence failed to show. Evidence only comes in through someone who's under oath on the witness stand or when an exhibit is admitted, which means if you wanted to testify to get evidence in, you'd need to take the stand. And the reason for that is that's because the state gets a chance to ask you questions too. Right. Otherwise, you could just get up and give an opening saying, I didn't do it, or it was self-defense, all that kind of stuff. And you can say those things in your opening, but it's not evidence. And I'll tell the jury that. And so if you chose not to testify in your trial and you didn't put up any other evidence, then the jury wouldn't be considering what you said in your opening or your closing. You understand that?
Yeah.
Okay. Do you understand that even though you know some of the law around criminal cases and this and that, if you choose not to have an attorney, you are losing the value of an independent perspective on this case, someone who is not connected to what happened or didn't happen in this case.
What you mean by that?
One value of an attorney is that that person comes in and looks at the discovery and says, hey, I'm coming in from the outside. I wasn't there. I don't know you. I don't know Mr. Baker. I'm telling you right now, this looks real bad. There's surveillance footage and you're wearing a t-shirt that says Ricky Pierce and your fingerprints are on the gun and your DNA is at the scene. I'm making this up, but a lawyer could say all this and say, look, Pierce, you need to work this case out because the prosecution is going to run the bus over you and back it up and run it over you again with all this evidence. That's a lawyer having a hard conversation with you, if that's what the evidence was. But you also might have a good lawyer look at it and say, they have nothing on you. You were merely present. Baker had the gun. The video footage shows Baker shooting the guy, and you're standing there looking as scared as the poor guy who got shot. I don't know what the evidence is. I do know that having your own lawyer means someone who is independent, who isn't running the risk of going to prison, can look at this and say, this is a good case for you, or this is not a good case. You will never get that independent assessment of the strength and weakness of the state's case if you represent yourself.
Right.
You understand that?
Yes, sir.
Okay. Do you understand that the prosecution will be free to bring in the most experienced attorney it wants? I won't say, hey, Pierce isn't a lawyer, so you need to bring in a brand new prosecutor who's never tried a case before, so it's more even. Understand that?
Yes.
They could bring in the big guns, and that's your problem and not anyone else's. Understand?
Good.
Okay. Do you understand that I will not ever tell the prosecution to go easier on you as the opposing side because you're not a lawyer?
Yep.
I'll expect them to treat you as respectfully as they do defense attorneys because you ought to be, you're the other side, but they aren't going to need to pull punches with objections or anything like that. If they think something wrong has happened, they're free to object. You understand?
Yes.
Okay. Do you understand that if you are found guilty at trial, you will not be able to argue on appeal that you were a bad lawyer for yourself?
Understood.
Because that's a claim that a defendant can always make if he's got a lawyer. It's called ineffective assistance. See, you know stuff, but you cannot say I was ineffective, meaning Ricky Pierce was ineffective.
Right.
You may have been very ineffective, but you don't get to argue that if you're your own lawyer.
Understood.
All right, you're understanding all the stuff you need to. Do you understand that you will not get extra time to prepare for trial just because you're representing you're gonna have plenty of time. Trial's not tomorrow. But if you say, you know what, I need a year to get this done, I'm gonna say, no, you don't. You're not gonna get any more time than I would give the lawyer that I would appoint to represent you. Or if you hired a lawyer, I wouldn't give that lawyer a year to get ready. There's a family that's grieving because of a loss. You're sitting stuck in jail. And so we need to move this case along. I'm not gonna rush it, but I'm not gonna go slowly just because you represent yourself.
Understood.
All right? Do you understand, and this is something we've already talked about, but it's important we cover it again, your ability to investigate this case and do legal research will be very limited by the fact that you're choosing to represent yourself and you're stuck in jail.
Yeah.
You got that? You appreciate that's a disadvantage,
Yeah.
but it's a disadvantage you're willing to eat.
Yes.
Okay. All right. You understand if you had a lawyer, you hired one or I appointed one, that lawyer would not be stuck in jail with you. That lawyer would be able to go out and you could say, hey, you need to go interview Fred Smith. And they'd try to find Fred Smith. And they'd have an investigator who could try to find Fred Smith. You understand that?
Yes.
You're going to need to figure out how to do that on your own. Right? Okay. Now, if you had a lawyer, you understand that that lawyer could give the opening statement for you, could do the jury, we call it voir dire, but questioning jurors in advance when you're doing jury selection, could interview witnesses, subpoena witnesses, prepare jury charges, do closing arguments, cross-examine the state's witnesses. A lawyer would, should, and could do that for you if you had a lawyer. You understand that?
Yes.
And you won't have any of that if you represent yourself.
Yes.
All right. Has anyone threatened you to get you to waive your right to a lawyer?
No.
Has anyone promised you something to get you to waive your right to a lawyer?
No.
Mr. Pierce, do you want to represent yourself, at least for now, in this case, understanding that the only way you can undo that is by saying, I hired someone. Here's this lawyer for me, because otherwise you're telling me, no, I got this. You understand that?
Yes.
And do you want to represent yourself?
Yes.
Okay. Well, I find, and I'll get this in writing and enter an order to that effect in the docket, that you're aware of the charges against you: murder, felony murder, aggravated assault, armed robbery, etc. The consequences you face if you're found guilty, up to life without parole. The advantages of having a lawyer, outside investigation, independent opinion, legal expertise, etc. The disadvantages of having no lawyer: hard to investigate, hard to do legal research. But I find that despite all those things, you have made a knowing, intelligent, as in you get it, and voluntary, no one's forcing you, waiver of your right to counsel, and you are exercising your right to represent yourself, and I'll grant you that right. Any questions about any of that?
No, sir.
Okay. We got, so two things. One, I'll make sure that, Mr. Abate, is this your case? Okay, that's your prosecutor. I'll make sure Mr. Abate gets to me as much paper discovery as they've got. Again, there's often lots of digital discovery, and I'm making this up. I don't know what's in the case, but let's say your cell phone was seized. They might have done a cell phone dump, and there's a big old file that lists all the pictures and texts, and sometimes, maybe not in this case, after something happens, Baker texts to Pierce, uh-oh, I can't believe we shot that guy. And Pierce says to Baker, hey, we need to not talk about this anymore. I heard the dude died. That's great evidence for the state, but that's digital evidence. And so that might not be something that can be handed to you to look at in
How would
jail.
I access?
So what you'll get is all the paper discovery as well as a list of what is the digital discovery: body cam footage, surveillance footage. And then you would let me know. We'll have a status conference so I can see how things are going. Hey, Judge, there's some things I need to watch. And we would set up a time when you could be here and there'd be a laptop and that stuff would be there and you could watch it and take notes, whatever you need to do. It's not convenient for you, but that's how it works when you are representing yourself and you're stuck in jail. So my answer is not you can never see it until trial. It's just we have to develop a little bit of a workaround. And so you'd be watching it here. You can't just watch it anytime you want. We'll set up a specific time and that's how you digest it. Okay? I'm not saying there's any digital discovery, but if there is, that's how we do it. So I'll get from the state the discovery. We'll figure out how to get it to you. Either we'll bring you over here and hand it to you. That's often my preference because it's on the record. I see you getting the discovery. Or through the sheriff's office, we'll get it to you. Are you at Rice Street?
Yes.
Okay, we'll get it to you at Rice Street. Mr. Abate, what would you say the ratio is in this case of paper discovery to digital discovery?
A lot of digital discovery. There's
Okay.
like Mr. Baker's cell phone extraction, and there's a lot of video surveillance, some of which this defendant, Mr. Pierce, is seen in high definition video shooting the victim in the head.
Okay, so there are things he'll need to see. Okay. When you generate the paper discovery, would you please include, you don't need to list the description of each video, but 9 surveillance footage, 9 surveillance videos, 2 body cams, whatever the generic count is. So Mr. Pierce knows, and then he can be keeping track. Wait a minute, I've only seen 1 body cam and it says there are 2. We can sort that out. Thank you. So you'll get the paper discovery, and then clearly we're going to need to figure out a time when you can come here and watch it. You get to watch it privately. The prosecutor's not going to be there while you're doing it because you may have a reaction to it, and take notes, whatever you need to do. That's number 1. Number 2, are there things that you think we need to talk about now, or now that you represent yourself, are there instead things that you want to get in writing and file as motions?
Yes, I have 2 motions that I want to file. I have them wrote up now in my thing, and there's a lot of issues that I have to address as far as with me being a national, just putting it on a record for my benefits.
Okay, so let's do that. Let's do 2 things. 1, I want you to put on the record, we're going to just do it. You're free every time we're in court together to remind me that you're American State National and you don't think that there's jurisdiction. But what I would ask you to do, you're going to share, it sounds like a fair amount right now, to get it on the record. We only need it on the record once because you will have made that record. And then in the future, all you need to do is say, hey, I rely on the record I made. You don't even need to state the date, but that I made before about my objection to jurisdiction or whatever you want to call what you're about to share. So I'll always let you make a record, but I will push back a little bit if next time I see you like, hey, I need to make that same record again. No, you don't. You made it, and you only need to make it once. And then there's a transcript so that if you need to take something up on appeal, they only need to read it once. All right?
Would I get transcript from every court proceeding? Or how do that work? Do I have to file for it?
So
or automatically get it to me? I'm representing myself.
So every time Ms. Rivers is taking something down, we can create a transcript. We don't immediately generate transcripts because, for example, if you go to trial and you're found not guilty, we don't need to create a transcript of any of that because you're done. You go home. If you're found guilty, then we need to make transcripts of everything because all that goes to the Supreme Court for the appeal. Between now and your trial, we typically don't create transcripts unless, just as an example, let's say we had a suppression hearing and the lead detective testified and talked a lot about the work that she did on the case. Everyone wants a transcript of that because she's going to come back at trial. And if her story changes, then someone wants to say, wait a minute, you were in court 2 months ago and you said Mr. Pierce was wearing a blue shirt and now you're saying he's wearing a red shirt. Which one is it? And the jurors are wondering, why is this detective changing her story? But things we're saying today, that kind of transcript we'd make only if you're found guilty and we need to push stuff up to the Supreme Court. But it is being preserved if Ms. Rivers is here and doing what she needs to do, which she is. So why don't you briefly share with me the things you want to get on the record?
Your Honor, let the record reflect that I'm American State National, which is a private American. I'm here on a special appearance to administer the affairs of the All Caps Trust. I am the living man, Ricky DeMond Pierce, and not the All Caps legal fiction, corporation, or dead entity. I stand on the land and soil jurisdiction, and that's the highest jurisdiction on the man. This is my oral request of me changing the court's jurisdiction over me here today. I have not contracted with the court in any kind of way, and I don't plan on contracting with the court in the near future. I have been forced to come here against my will and God-given rights under threats enforced by your government officials, which is kidnapping. Your courts have no jurisdiction over me, and I stand on the land and soil jurisdiction and have proof of it when I came to court on January the 30th, 2025. Your courts, plus in Louisville versus Motley, if any tribunal finds absent of proof of jurisdiction over a person and subject matter, the case must be dismissed. Your court's jurisdiction is the jurisdiction of the sea, which is the admiralty and maritime laws, which is also a military tribunal, and the courts are known as a ship of war, a privateer, or a battleship. I am under public law, which is common law, which is also the law of the land, natural law, God's law. I have God-given rights that can't be violated, and the courts are under admiralty and maritime laws, which is a foreign law to sea jurisdiction. See Article 3, Section 2 of the United States Constitution. And no living people live there, only dead persons, legal fictions, corporations, and dead entities. Because all cities are considered dead entities, which is another reason why you have to dismiss this case, because the living cannot be judged by the dead. Another problem the courts have, because my God-given right says I have to be tried amongst my peers and a jury of living people, which is American State Nationals, and also can't happen because our nationals is not under the court's jurisdiction and will not show one order because they hold a higher jurisdiction. In the original Constitution, Section 3, Article 3, Section 2 states that the United States, the corporation judicial power is under admiralty and maritime jurisdiction. And I am under the land and soil jurisdiction, and I have gave courts proof of this when I came to court January the 30th, 2025. I also mailed off my executive letter, the notice that President Trump sent off January the 4th of this year, letting all patriots know that these laws have been dissolved due to breach of oath, due to fraud and breach of oath for office. And I also mailed off a copy of my certified mail. I mailed off certified mail and have been received. I am also requesting your oath of office, Your Honor. The notice that Trump sent out goes as follows. Notice to patriots, date January the 4th, 2025. This is to inform all patriots that effective immediately, our government and government corporations are hereby dissolved due to breach of oath. Additionally, our statutory and foreign laws are also dissolved. The only legal framework that remain in effort are constitutional law as outlined in Article 61 of the Magna Carta and established common law. This directive is especially for corporate bodies and government workers. Any government corporate body, including police, judges, lawyers, and any individuals operating in these capacities must cease operation immediately. Those who continue to operate after this notice will be liable for prosecution for fraud and breach of oath. It is imperative that all government workers comply with this directive. Failure to adhere may result in serious consequences and even including potential military actions. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, from without the United States of America, the de facto government, and without the United States of America, the corporation territories. I reject, renounce, and remove all powers of attorney granted to me or issued under my name prior to this day. My birth certificate was the only contract that subjected me to these laws, but the birth certificate contract is void because I was only a minor and had no knowledge of this contract when it was constructed, which makes this contract void, which means the court lacks subject matter jurisdiction over me. I am no longer an employee of the government, which is the corporation government. I declare on the penalty of perjury on the public law of the capital T, United States of America, the de jure government, that I reject, renounce, and remove any and all alliance to any king or prince, any foreign state, any foreign government or flag. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself to any incorporated entity at all, but including but not limited to any incorporated church, synagogue, masjid, or temple. I declare on the penalty of perjury on the public law of the United States of America, the de jure government, that I have never knowingly, wittingly, or voluntarily pleaded myself of any foreign state, foreign sovereign, or separated myself from my birthright political status as American state national. I declare, publish, and affirm on the penalty of perjury on the public law of the United States of America that I am a lawful inheritor, acting with full rights and authority, responsibility, and honor now and always while my tenure on earth shall last. I, the living man, Ricky DeMond Pierce, affirm and declare that I have returned to my lawful birthright political status as a Georgian, and I have copyrighted and trademarked the all caps name, which is a trust and not the living me. I have occupied my executive office and never gave the courts any permission to use the all caps name, which is fraud. I have over 40 violations that the courts have committed upon me and my God-given rights as American state national. And I have counted over $800 million in violations over the time that I have been incarcerated at Fulton County Jail, these 150 plus days, and it's only adding up as I sit in Fulton County Jail against my will and consent. And they are as follows. 1, these are all combined municipal and territorial notices of violations against Americans with failure to perform any and all occurrences listed below in this section, starting at $10 million. A, notice of claim of sole relief and remedy. B, notice of violation of the Landman Act, attempted attachment and seizure of unregistered trademarks, Title 15, Section 1125, 8, and 11. Notice of violation of admiralty and maritime and prior cases, Title 25, Section 1331, 1, 2, and 12. D, notice of violation for special maritime and territorial jurisdiction of the United States, Title 18, Section 7, 1, 3, 8, and 13. E, notice of violation of the Postal Accountability and Enhancement Act of Title 39, Sections 1-3908 and 3621-3591. F, notice of violation of presumption of the Public Vessel Act, Title 46, U.S.C.A. Appendix, Section 781 through 790, as originally enacted. G, notice of violation of the False Claim Act, Title 31, U.S.C.A. Sections 3729A and 7. H, notice of violation of the Foreign Sovereign Immunity Act, Title 28, Section 1602 through 1611. I, notice of violation of the United States Statute at Large Act, Title 12, Section 411. K, notice of violation of the Geneva Conventions by the United States Department of Defense.
Mr.
United
Pierce,
States.
Mr. Pierce, I'm going to just pause you for 1 second. You were on K. How many letters? I want to make sure
I'm
you're almost done because we're getting into international stuff and that's getting a little far afield.
All right. 2, private easements fee schedule. Penalty for private use, $250,000. These fees will be mandated upon the informant listed on the warrant, citation tickets, arrest warrants, detention orders, and seizure orders. Composing to produce trade name or other identification materials. A, name, $50,000. E, fingerprints, $200,000. F, photographing, $200,000. G, DNA, $5 million. Blood sample, $5 million. Personal property, trespass, carjacking, theft, interference with commerce or trade. M, color law, $150,000. N, implied color law, $150,000. T, fraud, $1 million. U, fraud upon the courts, $2 million. BB, stimulating legal process, $1 million. Use of trade name and copyrighted protected material on a threats, duress, and or coercion. Name written by a informant, $250,000. Miscellaneous material written by a informant, $500,000. Court appearance fee schedule. These fees must be paid immediately after my case is finished. Failure to pay fines and fees will result in an additional fee of $5,000 for breach of contract. Demand for appearance in court. My appearance on the protest and duress per hour, 1 hour minimum, $75,000. Use of trade name material.
How many more pages do you have?
I have quite a few.
Okay, so I'm wondering if, and I'm not going to curtail you too much, but you'll be able to file that, which will make it even more of a record if you want it to be filed, or you could give it to me and I'll file it for you. But that's up to you. What I don't want to do is I want to make sure we're moving your case forward, and this is pretty lengthy. It might be more efficient to have it filed into the docket so that we actually see, hey, there it is in the computer system.
I really need to get it on the record, and I need to file a motion to be able to address these issues also. I have the motions already wrote. If you give me a little time, I can get through it pretty quick.
Well, I don't want you to read too fast because Ms. Rivers needs to be able to take it down. Would you say we're more than halfway through, or are we not more than halfway through?
Yeah, we're halfway through.
Exactly half or more than half?
Exactly half, because it's 20 pages. I'm on 11 now.
Okay. Well, let's go. Don't read too fast, but don't read too slowly.
Trespass and failure to act fee schedule. Use of trade name material, name on the protest and duress, $25,000. Miscellaneous material, $25,000. Time uses for court appearance, 30 minutes on the protest and duress, $33,500. 60 minutes on the protest and duress, $75,000. 90 minutes or more on the protest and duress, $100,000. Trespass and failure to act fee schedule. Trespass by public officials, police officers, judges, detectives, attorneys, corporations, and other fictitious entities as well as any other who desire the contract. A, trespass on American homestead land, $10 million. C, failure of attorney to file requested FARA form, $1 million. Failure to accept American State National card, $1 million. Failure to honor God-given rights, $20,000. Failure to honor oath of office, $50,000. Failure to honor constitutional oath, $50,000. Failure to honor written and oral word, $5,000. Failure to honor a bond/no bond, $5,000. Detention from free movement and or cuff per hour, 1 hour minimum, $75,000. Incarceration per hour, 1 hour minimum, $75,000. Failure to follow federal and or state statutes, code, rules, and regulations, $50,000. Failure to set a claim upon which relief can be granted, $25,000. Failure to present a living injured party, $100,000. Total damages for each line set forth in a above schedule will be assessed as the total amount of damages as set forth herein times 3 for a total of all damages added to 3 times the damage for appearance and other additional damages for a total of $1,019,631,000 US.
1 billion, you're at to the B.
Yes. that's
Okay,
$1
that's a
billion.
lot of money.
And that's just for the amount for me being incarcerated these 120 plus days. Your Honor, all laws are commercial, and all laws are not laws, but codes, statutes, mandates, regulations, and all the rest. And I'm a private American or not under commercial law. What's legal aren't law, Your Honor, and what's law aren't legal. And Your Honor, ignorance to the law is no excuse, and that goes on both ends, mine and yours. This declaration is valid, true, correct, and complete in all jurisdictional law, air, land, and sea. Your Honor, let the record reflect that if you are against this, this is warring against the Constitution. And warring against the Constitution is called piercing the veil. And piercing the veil is called treason. Treason is punishable by death, and there is no remedy for treason. Also, in Orange versus Independence, officers of the court have no immunity from persecution when violating the constitutional right. I am honored the United States of America, the Judicial government, the Confederation of the States.
Mr. Pierce, there's one phrase you've used a whole bunch of times, and I don't understand it. The what government?
The Judicial government.
What is, spell that?
D-E-J-U-N-E, space J-U-N-E, Judicial.
D-E-J-U-R-E. Oh, got it. Okay.
Judicial.
Yep. Thank you.
Okay, which is the Confederation of the States. And the Federation gave the United States, the corporation, the de facto government, the power to operate out the 10 square miles, which is in Washington, D.C. And any laws outside of Washington, D.C. is commercial. And private Americans are not under commercial laws. We are under public law, which is common law. My God-given rights has been violated by being forced to give my DNA, fingerprints, eye pattern, and blood DNA against my will. I never consented to them arresting me or detaining me after I put them on notice of my political status. Your Honor, United States, the de facto government, is a for-profit corporation, which means they have a Dun and Bradstreet number, and no corporation can interact with a living man under another corporation. Your Honor, it states that every man is independent of all laws except those prescribed by nature. No man or woman is bound by any institution formed by his fellow man without his consent. See case law, Cruden versus Neal, 2 N.C.338, May term 1796. Your Honor, in 1845, the then Pope and the British Monarch States Trust, and both of whom acted in gross breach of trust, agreed that the American experiment was not working. The whole idea of self-rule was antithetical to the idea of divine rights of a king's supremacy. So they signed a secret treaty of Verona and agreed to undermine the American government. The British Monarch Commercial Company, which controls the bankers and lawyers, issued license to lawyers to act as privateers. That's why the Bar Association requires licensing. Acronyms for bar mean British Accredited Registry. Anytime we see the word license, it means that someone in a position of rulership is giving someone else permission to do something that is otherwise illegal. In this case, the king gave the members of the Bar Association permission to act as privateers against American commercial vessels. Because the jurisdiction where they attack us is international, admiralty, and maritime commercial laws. And that's why you see the gold rings around the flag, around that war flag, because the war flag is a war flag representing that the government is at war with the citizens. See 1864 Naval Agency and Distribution Act. Again, also, the United States was incorporated by the Pope, and the laws we are bound by are foreign laws from Great Britain, which means that the United States, the corporation, got Americans bound by laws from Great Britain, which is also illegal. That's why, again, you have BAR, which stands for British Accredited Registry.
What page are we on?
What am I almost doing now? I'm closing now.
All right.
Again, I am 1, changed from jurisdiction of the courts. I have a high jurisdiction. 2, I am demanding to see the state of Georgia to show up in proper persona. This must be made by self and not an attorney. 3, I am demanding that the courts present a living injured party because our citizens are considered dead entities, corporations, legal fictions, and artificial persons. 4, I am requesting the judge oath of office and the first and last name of every court official in this courtroom before we proceed. I am demanding to see who gave the courts permission to use the all caps trust, which is a copyright and trademark. I'm putting the courts on notice that I have occupied my executive office again, and I'm standing in my full capacity as American State National, and I hold the highest court here today. I am demanding you give me a full relief for my case by either dismissing this case or giving me a bid bond signed and paid through my all caps trust. I am also filing an order of pro se ex parte with prohibition to dismiss my case for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction. Your Honor, I, the petitioner, case will not being handled in the proper courts, which is common law courts. I, the petitioner, was not put on notice by a state-appointed attorney that my case was not handled in the proper courts. I, the petitioner, never signed a contract to be subject to the jurisdiction of the United States and or the District of Columbia. Again, the birth certificate and Social Security card are voidable contracts that was constructed when I, the petitioner, was a minor. So these contracts could have not been knowingly, voluntarily, or willingly consented to because as a minor, I, the petitioner, lacked the capacity to do so. Again, I am making a clear and unequivocal demand to petition the state to show up in proper persona. The state is a legal entity, and a legal entity is an artificial person. And an artificial person is a corporation, which cannot appear in proper persona. See case law, Penhollow versus DOANES. This vagueness doctrine may invalidate criminal law for two independent reasons. First, it may fail to give a proper kind of notice that will enable ordinary people to know what kind of conduct to prohibit. Second, it may authorize and even encourage arbitrary and discriminatory enforcement. Your Honor, a basic principle of due process that a law is unconstitutional if its prohibitions are not clearly defined. Plus, I, the petitioner, cannot owe a debt in a bankrupt nation, and no title of nobility shall be granted by the United States. See the United States Constitution. Again, Your Honor, I, the petitioner, cannot have a fair and impartial trial when the judge, the jury, the bailiff, the district attorney, and public defender all work for the state and are one and the same. See the case law, the Maggie Hamlet case. Your Honor, the Constitution is a chapter of negative liabilities. Liberties, excuse me. It tells the state to let people alone. It does not require the federal government or even the state to provide services, even so elementary as maintaining law and order. See case law ID, period, CF.OLMSTEAD versus United States 277 US.438 and 478 1928. And again, Your Honor, any judge or magistrate who does not comply with his or her oath to the Constitution of the United States wars against that Constitution and engages in acts of violation of the supreme law of the land. The judge is engaged in acts of treason. See case law Cooper versus AURON, 358 US.1, 78H.CF.1401, 1958. Your Honor, the authentication of my birth certificate signed by the Secretary of State, the Secretary of Washington, D.C., and the Governor of Georgia is admitting that the government made a mistake by making me to abide by a void contract and subjecting me to the jurisdiction and laws of the government when I had no knowledge of this contract and was too young to even know that this contract exists, that the government tricked me and my parents into without our knowledge and consent. And the courts have a copy of my birth certificate authentication also. Your Honor, I am a private American, which is American State National, and cannot be represented by a bar attorney because an attorney is an officer of the court and will automatically subject me to the court jurisdiction.
And I hear you on that, which is why we had the first part of our conversation, and I've concluded that you've got the ability to and the desire to represent yourself. We'll do that. I appreciate you making that record. As you and I agreed, you won't need to do that again. You've now made all those objections, made it very clear that there's $1 billion plus, and I get it that that number is increasing. Every day you're in custody and people are trying to contract with you when they shouldn't, all that. You've made a healthy record of that. You are welcome to file things now because you are your own attorney. You can now file things of record into the docket. But when we see each other again for whatever the next court event is, we can use a shorthand where you can say, I renew the objections that I made on the record when I was last in court. And that way you're not going to need to break your vocal cords by going through that again. But that was very thorough, and I appreciate you making that record.
So is I can leave these motions here today?
So, this one time, I'll take responsibility for filing things for you.
You know what, I'll wait, because I still have some other.
You want to do more work on it?
Yeah.
Okay. There is a way for you to file things from the jail, and they ought to tell you about that, but you can get things to the clerk's office. Don't mail them to me, because if you mail them to me, I'm not the clerk. They won't get in the docket. They go into my inbox, and I've got my Pierce collection. You should also know if you send things to me, I probably need to send them to the prosecutor as well, because we can't have what we call ex parte conversations. In the same way that the prosecutor can't call me and say, let me tell you what Pierce did. That won't happen. If Mr. Abate wants to talk about this case, you need to be in the loop as well. And so we'll bring you over here, or if it's real simple and technical, we'll get you in a Zoom booth so you can see and hear. But if it's anything substantive, you'll be here in person in open court for that, okay? So what I see as our next steps, then I'll see if the prosecutor has anything else, and I'll see if you have anything else, is that I'm going to get a scheduling order in that gives a deadline for Mr. Abate to get together the paper discovery and then a list of what the digital discovery is, and we'll figure out how best to get that to you. I need to enter an order that says you get to represent yourself, so that's in there, and then we move forward.
Okay, cool.
What about you? Yeah.
Last time I was here when I went to trial, they had where I went to the law library and look at video footage. That's not possible anymore. Well, yeah, I can.
I don't know. Meaning you went to the law library at the jail,
yeah,
and you were able to like.
They had an officer supervise me to watch the videos.
Okay, why don't you ask? That's a question you need to ask the folks out there. I don't control the sheriff's security protocol. They may still do that. They may have cut it off because someone said it's video footage and instead it was an adult movie or something. And that's not you, but someone may have done something that abused that privilege. So ask, and if the answer is there's a way to do it, we'll make it happen. What I do know works, because I did it the last time I had a pro se defendant, is that he came here and we had a laptop. The prosecutor brought in a laptop and said, here's the directory, here are the 5 videos. Prosecutor went away and you hit play and you got to watch them. Took whatever notes you wanted and then you went back. So worst case scenario, we'll do that. But if you figure out there's a way to do it at the jail, then we can talk about making that work.
Who I need to contact? I think I need to contact the sheriff office, the sheriff or something.
It would be someone at the jail. I don't know who you talk to if you want to go to the law library or if you've got a headache and you want a pain pill. I would talk to staff out at the jail. Hey, if I want to do X, is there a way to do it? If they say there's not, then we got to do it over here. Okay.
Understood.
Any other questions?
No, sir.
Mr. Abate, what do we have from the state?
So on the last issue you just, or Mr. Pierce just raised, I don't believe the jail does that anymore.
I don't either, but
the USB and the or CD, they just don't allow that kind of what they would call contraband at this point. So we can ask, or he can ask obviously, but just for efficiency purposes, I think.
Start with the law library. Just see the law library still do it.
You should ask, but don't be disappointed if the answer is no. I think there were issues with, a USB drive is so small and it ends up in someone's pocket and then it's on the 7 North and I'm not saying you did.
Is it part of me possible they I ain't gotta take it. They can stick it in, sit there, watch the whole video.
Hey, if you can sell it and make them do it, that's great. I'm not saying no. It's not my call. It's not his call. That's 100% the chief jailer's call. And they may have said, we're not doing it anymore. And if they're not, then you come over here and we'll make it happen. Anything else?
No, Your Honor, I'll get paper discovery this week.
Great.
To Your Honor, and then I will, in abundance of caution, put all the digital media on the drive just in case.
Good.
And regardless.
Well, and that'll be helpful because if you include that with the paper discovery, then you don't even need to be in. If we can get our hands on a laptop, then we'll let you know when Mr. Pierce is coming over, but we may not need to impose on you to show up with the stuff loaded on a computer. I don't know. I don't want to get in the middle of the technical stuff, but I do want to enable Mr. Pierce to see what the state has.
I have no problem logging in the laptop when he's here. We did that with Judge Ingram on multiple occasions, but it seemed to work pretty efficiently.
Good, I think so.
And Mr. Pierce is an ANC recidivist, so he is facing a convicted and mandatory life without parole sentence.
Okay, and is there a recidivist notice in the docket?
Not at the moment. I intend to file it.
Okay, Mr. Pierce, I'm gonna translate that for you. You may already know what it means, but because of your criminal history, the state has the ability to file a pleading, which it sounds like they're gonna do, that if you're found guilty, and all this is contingent on a jury finding you guilty. If they find you not guilty, none of this matters.
Okay.
But it's a big if, and if a jury comes back with guilty, I had mentioned that the maximum possible penalty was life without parole, but if you'd never been in trouble before, that's not a mandatory sentence. Life, I'd have to impose life, but I have the option to choose between life without parole or life. Unless you've got sufficient criminal history and the state files this notice. And if they do that and they've got certified copies of your convictions, then that takes that discretion away from me. And the only sentence you can get is life without parole. And that may be where we end up, but they haven't filed it yet. When they do, we'll figure it out. But it's important that you be on notice of that, because sometimes the defendant thinks like, hey, you know what, if I'm found guilty, it'll be life. That's a long time, but it's parole after 30 years. But if life without parole is the only option, it just may make you think differently about the case. Don't know, but we'll keep you posted. Okay? I appreciate everyone's patience. Mr. Pierce, we'll get you back here either because you filed something we need to talk about, or it's time for you to look at the digital discovery. All right?
So, question before we go. How much, do I have like a certain amount of time to file all the motions that I need to file, or how do that work?
So there'll be a scheduling order that comes out, and we'll need to make sure it gets to you. And that's got a deadline for the state to get discovery. And then you've got a deadline after that, so you can see all the discovery to file motions. Okay. You can always file a motion later on. I just don't promise you that I'll get to it before we get to trial, because you want to avoid a defendant just before trial. It's like, oh, I got another motion and another motion. So you're going to want to start filing things. If you already have them here, put them down on paper and start filing them. But you'll get this scheduling order that's got the cutoff where anything filed after that date is out of time, and I can choose to ignore it, and I don't get in trouble with the Supreme Court.
Okay.
Okay.
And question, I know I've been having a conflict with attorneys, so does my time from this day, today on forward, start me to file my speedy trial? I know it's a certain time frame for you to file a speedy trial. So does that time frame start now, since we have an understanding?
Right. It started from when you were indicted and not now. So you can still file, well, I'm not going to give you advice. You should file what you want to file, and we'll work through whether it's a mandatory speedy trial or if it's a discretionary one. But I'll tell you, no one's interested in slowing this down. Mr. Baker is on a trial calendar that starts in a week. And I'm having to slow that down because really you two ought to be tried together, unless someone can convince me that you shouldn't be tried together.
You're going to try it together even if I'm not a citizen?
Yep. We can try a citizen next to a non-citizen. That's not, the only reason you don't try people together is if there are reasons why there's some evidence that can only come in if they have separate trials. But I leave that up to the lawyers and you to work through that. My default is always to try co-defendants together. And Mr. Baker's case is ready for trial. So if you say I want a speedy trial, no one's going to say, no, let's slow it down. They'll want to move it along. But you file what you want to file, and I promise you we'll work through it. Okay? Okay. All right. Thank you, deputies. You can take Mr. Pierce back.
All right, guys. We have one little bit left. And that little bit is with Judge Simpson. This is the kid that we've been following for the last few weeks. And you'll know it as soon as you see it. Let's get right into it.
Court does call the case, People versus Caleb Smith.
Lawrence H. Margolis with and on behalf of Mr. Smith, who is approaching. Caleb, please state your name for the court.
Caleb Smith.
Thank you. Judge, we are waiting on a couple additional discovery supplements, I believe, from the prosecutor's office. I know there's body cam as well as a download of the phone that hasn't been completed yet. I spoke to Mr. Childers, and for him to be available the next time, we'd like him to be here since he's has a understanding of this matter, and I've been working with him. Would be that, what was that, Andrew, 27? 27. We'd like to.
We don't pick.
Sorry?
We don't pick dates.
Yeah, we're seeking to adjourn it for a couple weeks.
Yeah, just
Part of the discovery request, there was, this is a U of M Police Department case, but Ann Arbor Police ultimately apprehended the defendant. I was able to get that video at the end of the day yesterday, so Mr. Margolis should have that momentarily. And my understanding is Detective Matthews with U of M Police was at our office earlier today helping off some discovery. So
this one was, oh, my teacher told me to put there. So, verification.
Probable cause conference will be adjourned March 27th, 2025. 9 a.m. or as your invite indicates. As to bond, how's it going?
How's it going?
It's going good. Attended school and church. I've been going daily, regularly. And my grades are as if I have them right here. I'm really to show.
May I approach?
Those are the grade classes, like similar here.
And the ones that are not the marks that we would want and expect, we've been advised that those were the weeks that he wasn't here, and those grades are going to be changed imminently.
His participation grade.
Yeah, you have to be in class for cooking.
What'd you send me the other day? A pizza?
Breakfast now.
Nice.
You can do better than this.
Yes, yeah. Yes.
How's it going with him?
Better. Seeing a therapist, and I even haven't enrolled the one in tuition
Pardon?
in a mentoring program Saturday.
Oh,
Signed them up for it, but we can't discuss that yet. A little bit better.
I did forget to let the court know that Miss Barrow has requested, there's a mentoring program, and I can get the prosecutor in your office some information on this. She just let me know about it. It's in, where is it? It's in Ypsilanti. She's wanting to, what's it called?
With
my brother's keeper. He was hoping to be able to attend that.
All right. Well, get that information to the prosecutor. I'm aware of their services and programs, so it might be good for him.
I'll get that to them immediately.
Probably outside of myself, they'll be able to tell you that you're not all that. Sometimes you're special, but you're not that special.
Understood.
All right, but everything else is going good with you?
Yeah.
Caleb, why do you think I threw you in jail?
Well, to learn a lesson and
to do what?
So like what I believe me is to learn a lesson and that to know.
Okay, I'll accept that. What lesson do you think I wanted you to learn?
Like, excuse me, if I take a moment, just processing it. To sorry, I'm just to like help me realize this is what I believe, to help me realize that like me, this is what I realize is that I'm not meant for this, or that to own up, like I don't know, just to say, like I'm just going to speak from my heart, and that sorry, I'm having trouble talking, but like the lesson I've learned was that I learned that I didn't want to be there, and that I would focus on school, and the lesson, even with the get a 3.5 and higher, I've been like aiming for that, and that helped me realize that I can like achieve it. And what else?
That's all I have for now. I'm sorry if I didn't say anything clearly. But I've learned a lot, and that my actions affect not only just me, but others. And that, what else?
Just want to keep improving.
Yeah, mostly just keep improving, and that's what I've been doing.
You nervous?
A little bit, yeah.
Why are you nervous?
I'm just not like used to this. Sorry.
Used to what?
Just being here, speaking out loud in front of.
You're not used to being in court, facing criminal charges, that kind of thing?
Yeah, I'm not used to.
Well, then you ought to conduct your life where that won't happen. Right? Part of the reason and what I asked you is why you thought I locked you out, what you were learning.
Mm-hmm.
You know, when you got here, just so that you know this, I watched your mother. And probably the only reason that you're out is because of your mother. A lot of times what people don't realize is that sometimes there is nobody else in the world that cares about you, trying to look out for you, praying for you, except your mother. And I watched that woman sit there as her son was going off to jail, and when he came back out, and in all of that, it was breaking her heart. But I can tell you, and I don't know your mom, but I can tell from the look, I can tell by her posture, she just kept praying. And throughout all of that, and even after all of this, and you, I'm not talking about the criminal charge, but you doing the stuff of violating your bond, that woman never gave up faith in you. That's who you owe it to. Remember something I told you about where you were going to run into problems with me?
Yes, sure.
What was one of the ways you were going to run into problems?
One of the ways was, well, that I believe that when you said, if I can't respect my mother or if I can't respect the courts, that was like a problem.
I always believe in letting people know where they stand with me. And I'm not shy. You disappoint her, I'm sending you. We're clear on that, right?
Yes, Your Honor.
Get those grades up. Bond will continue.
Thank you, Judge. See you.
Well, kids, that's all she wrote. That's all I got. The little puppies are looking at me like I'm crazy because I'm talking to nobody in particular, and they don't know why. But that's all I got. That's been the week in review. Those were some huge cases that happened over the week. I didn't necessarily make my own little videos about them because they were all over the place. But they were so great that I thought that they could not be ignored, and I felt that all you guys would have some interesting commentary to put over it. So here we are. This is what we did today. This is how we did it. Don't forget our regular shows every night during the week with Judge Fleischer or whoever is doing a docket. We have a premiere every night of the week at 8 o'clock Central Time. That's 9 o'clock Eastern Time. Come by, hang out with the live chat with us, watch docket for a while. We usually run for an hour, 2 hours, something like that. So come by and say hi. I'm your Lone Wolf Usul. I'm your host for these here videos, and I'm the curator for this here channel. And I do appreciate all of you, and I hope to see you again. Same Wolf time, same Wolf channel. next Saturday. We'll talk to you guys then. Love you guys. Have a good day. Have a good weekend. Have a good week. See you next time. I'm out. Love you, Mom. Most important thing you can say. Love you, Mom. Judge Simpson would be extremely upset with me if I didn't say it at least 3 times. Love you, Mom. Thanks for all your help. And love you all, Chad. We'll see you next time. Lone Wolf out.